Working with Judy on the library board the last few years, I've really enjoyed that. It's been a terrific experience. That's my second term as chair of the library board. The library is one of the great treasures central to the university. Faculty members take it enormously seriously. It's hard to get faculty members to focus on things other than teaching and research. The fact that we're willing to bring attention to the library tells you how important it is. So, and I'm confident that it's in very good hands. So, thanks for having me here to talk. I live right around the corner. So, I think this is the shortest distance I've ever traveled to talk. So, I think of the ratio. It was like a 2-minute walk, a 30-minute talk. So that's a good ratio. I've gone to, Paris to talk for 15 minutes. The ratio starts to get a little out of whack at that point. So, okay. So brunch with books on a Sunday. My God, what could be a better thing to do? We should do this every Sunday. So, but thanks for coming back for Alumni Weekend. So I was, asked to talk about something that might be of interest to a library-based crowd, and I do a number of things that I think are relevant to that. So you see the topic for today, digital copyright, control at a distance. We'll tie that into Google Book Search, among other things, which, as Judy says, we have been spending some time on. So focus on I guess the technology of books and the technology of content. That's in some sense what I'm interested in, the relationship between technology and copyright and effective protection for those. And I sort of divide the world maybe up into 4 eras, where we're sort of in the midst of the 4th era. Yes, exactly. So era 1 really goes back to pre-Gutenberg. So it's an era of incredibly hard to produce content, right? Where it's all handmade, one by one created content. I don't know why I chose this book, other than it's relatively easy to find an image from it. Maybe people in the room, you're a learned group who've read this book. I have not. So, but the focus for me here is what does it take to make this book? And then, having made the book and put the book into someone's hands, what is their ability to create a copy of the book? Because one of the things I care a lot about is reproduction, right? Copying. That's in some sense what copyright is about, one of the subjects I teach and write about. And so understanding the technology as it relates to copyright. So this is an era of what I call high symmetric copying costs, which means it's very, very expensive to make the first copy, but just as expensive to make the next copy, right? And symmetric, the author is no better situated to make the next copy than the recipient of the book, right? This is not an era of mass production. It's an era of one-by-one production, okay? Era 2, well, Gutenberg, right? So what Gutenberg obviously does is he creates an era in which copies can be created much more easily, right? I've been reading Adrian Johns' new book on piracy, about midway through it. If you haven't read that, recommend it. Adrian is on the library board as well, professor of history here. Right? What Gutenberg does, I think, is a couple of things, right? One is that Gutenberg makes it possible to, as I put it there, decentralize patronage instead of, in some sense, having to find someone in advance who would pay for the entire, as it were, production of the book. You can sell books individually, maybe through subscriptions, right? Maybe after the fact. The other point here is that Gutenberg creates a situation in which the recipient of the book now is no longer as well situated to make a copy of the book as the author, right? The author can produce books in runs. The recipient can't simply copy the book easily. Yes, there were reprinters. That's part of what Adrian's book focuses on, but reprinters were obviously other professionals. Gutenberg, 1455. That's an image of it from the British Museum. Era 3, cheap distributed copying. Well, where shall we date that? Well, maybe here, right? This is where I start. So if you've read Xerox corporate histories, I have. They're fascinating, as you might imagine. The Xerox 914 is the machine that made Xerox, By modern eyes, it looks a little clunky. This is 1959. But what it does is it creates real plain paper copies. And if you look at the number of copies made, right, after the introduction of the 914, they just take off. So technology changes. Now, putting a copy into someone's hands, at least of certain artifacts, right, makes it possible for them to make copies, right? Cheap, distributed copying. Xerox, 1959. Maybe we go here, right? So maybe we go to the rise of the cassette recorder, right? Sony, which was, I think unfortunately is the operative term if you've been following the introduction of the iPad in Japan in the last week, right? There's a great excitement about the iPad in Japan, but also a sense that Japan, which was this great electronics innovator, has lost its footing a little bit. But Sony was, right? Sony was, at one point, the firm that won, if you were an consumer electronics company, that was the company you would want to be, led by Akio Morita. And so the cassette recorder takes us from text, which was obviously what the 914 was about, to audio. And then maybe we go here, right, to the Sony Betamax in 1976. So we switch from text to audio to video, right? If you know the history there, of course, Sony was, in some sense, thought to be a superior technology. Ultimately, the standards war between Sony and the Matsushita-led VHS ultimately resulted in VHS winning, but with broad distribution of a copying technology, subsequent Supreme Court case history that resulted in the Sony case in 1984. Cheap distributed copying, right? Everyone can make copies. Copies of text, copies of audio, copies of video. Ooh. Era 4. Oh, one more, I guess. So Sean Fanning. Do we know who Sean Fanning is? This is sort of an age test, right? That's where we are, where it's funny to see how ages change in your classroom. Who's Sean Fanning?
Founder of Napster.
Sean Fanning was known to his friends as Napster, right? Napster was the first great peer-to-peer file sharing program. Now we've reached a point where if you say Napster to your law school students, they sort of stare at you blankly, right? That's not the technology they use to steal music. Oh, I'm sorry, that was the wrong characterization. To share music, yes. They use LimeWire and I don't know what else, right? Napster is as a name from a distant past. But Sean Fanning, known to his friends as Napster, right, launches this peer-to-peer file sharing program. And what that means is, and this is where the technology takes us to, is that for a very long period of time, I could take an artifact of content, right? I could put it into your hands, right, and be confident that in doing that, I didn't make it possible for you to copy the content, right? The technology of copying was sufficiently rudimentary that the distribution of the content itself didn't mean that I was, in some sense, enabling competitors who could then distribute my content, right? The technology itself locked, controlled the content. But with the sweep of technology, right, with the introduction of the Xerox 914, the cassette recorder, the VCR, and then ultimately the internet is captured in peer-to-peer file sharing, right? At that point, technology no longer captures, locks, controls the content. And the question is, well, where does that take us? Okay? Well, the response to that is sort of what I'm interested in right now. And the response to that is interesting, right? And what I call, in some sense, the new book mediation. I have papers on that as well, right? We're drifting towards an era of on-demand publication. I gave a talk at our law school alumni weekend, 3 weeks ago on some research I'm doing on razors and blades, which sounds esoteric, I guess, and maybe is. I don't think so. For a conference we're having at the law school in a couple of weeks. And I walked into one of my colleagues and I showed him this book on the razors and blades business before Gillette. He looked at the book and he said, well, okay, that's fine. It's a book on razors and blades. What's the big deal? Then I turned to the back of the book and showed him what the big deal was. The big deal is that book was printed 3 days after I'd ordered it. That was what the big deal was. It's actually a pretty good book on razors and blades. But the technology of books, it looked like an ordinary book. Right? There was nothing about that that would have suggested that this was an on-demand publication. But that's exactly what this was. This is a book that is ready to go. They're ready to print it. This is, I think, Lula does this. But they don't have an inventory of books sitting in some warehouse. when they need a book, they print it, right? And 3 days later, I have it. So that's a very different world. Now, that book still looked like a regular book, but as more and more of our books are mediated books, where there's some device, right, that is actually showing us our book, whether that's a Kindle or an iPad. My iPad is currently sitting in Memphis, Tennessee. FedEx tells me it shows up Tuesday. It's a long journey from China to Anchorage to Memphis. But as more and more of our books are mediated books, right, then the question to ask is, well, how does the possibility of book mediation change these questions of locking, right? First part of the story, what I call, the great unlocking, is technology, the transaction costs associated with copying technology, in some sense, the physical medium protected it. That seems to be going away. As we move towards mediation of books, right, are we in some sense going to restore the possibility of locking these books, right? That locking will be interesting in and of itself, right? It means that in some sense we're very much back to the scriptorium, right, because it's an era of one-by-one production again, right? The Razors and Blades book I bought, they produced it the instant I needed it. It also means, and I have a paper on this if you're interested, that maybe we'll see more advertising-supported books. Some people react with horror at that idea. I can explain that longer if you'd like. But actually, I think that's quite interesting. I wrote a paper on that, and lo and behold, then discovered that Amazon had filed 2 patent applications. So I'm not the only one who thinks that might be plausible. And what that means then is that it seems to me we're going to go forward in one of 2 ways. And one way is we're going to embrace some sort of locking system, digital rights management. There's a copyright statute called the Digital Millennium Copyright Act, which validates a lot of that. That's on the table in a number of other countries. Or we're going to say, look, we can't really control how content is distributed. It's going to have to all be free in the sense of being advertising supported. That's what Google is. And that will have consequences itself. Okay? And so the question for digital rights management is a question of, well, to what extent are we going to allow people, Amazon, Google, to exercise control at a distance? What locks will we respect? Okay? That's what I want to talk about for the rest of today. So there's a history associated with that. I don't know where you want to start, but I think I'll start here. So this is a book called The Castaway. Anyone read The Castaway? No reason you would have. I don't think it's famous unless you're a lawyer. This is a Bobbs Merrill imprint. It's from, well, I can't quite read that. I'll say 1904. That's what the copyright page says. What's interesting about this is what it also said on the copyright page, which was this. Here's the book. You have to sell it for at least $1. Can't sell for less than that. Doing that will be an infringement of copyright. So Bobbs Merrill distributes the books, but wants to control the price they're sold at. There's a lot of this going on in this era. I teach antitrust. The great antitrust case from that era, which was only recently overturned, is the Dr. Miles case. Lots of efforts by manufacturers to exercise, as it were, control at a distance over the products they put into the marketplace. Here's what they were doing, right? Sell it for $1. Can't sell it for less than that. And if you do, it's a copyright infringement, which means we can chase you and bring copyright law to bear on you. That case went to the Supreme Court, decided in 1908. The Supreme Court looked at this and said, the statute that we have in front of us has a particular language formulation of what the Copyright Act is. We don't think that's included in that. The word was vend at that point. We don't think that's covered there. So Bobbs-Merrill, once you sort of hand off these books, you can't rely on copyright law itself to control the prices at which they're sold at. It also said, though, right, that this was just a question of copyright law. It wasn't a question of contracts, right? If you want to put contracts into place that somehow control this, you guys go right ahead and do that. It's not a copyright case. You want it as a copyright case. We won't do it, but we'll let you do it through contract. Of course, who could imagine a world in which every time you bought a book, you had to sign a contract for it, right? Maybe that's the world lawyers would like. Oh, that's so exciting, right? More contracts, more work. But who can imagine a world in which every time you bought a book, there was a contract in connection with it? That's crazy. Except not now, of course. We'll be to that in just a second, right? So Bobbs-Merrill says, okay, you guys want to try to exercise control at a distance over this work, want to try to rely on copyright to do that. The current copyright statute, subsequently amended, doesn't let you do that, but maybe you could do it through contract. You can buy this book. It's in the public domain. Go on Amazon and buy it for $38.65. Right? I always use that point to make clear that the fact that it's in the public domain, available to all, doesn't mean it's free. Okay. Well, so where do we go next? Well, so we go to Paul Whiteman and his orchestra. RCA Victor, his master's voice, I guess that's what all that is, right? The point I care about is right there, where it says, not licensed for radio broadcast. So what happens, of course, is that we see the emergence of records, the phonograph, the wax cylinder. I think I just went in reverse order. Eventually, radio shows up, and as radio shows up, radio then looks like competition for these artifacts. And they say, oh, we got to control that. So again, they turn to legends, right? Just like what we saw in the Bobbs-Merrill situation, they turn to that for records. So they put a stamp on the record, not licensed for radio broadcast, trying to separate the market, saying, look, we're going to sell to the home market. People can take these at home, play them at home. But you, the radio guys, you can't use our music to compete with us, right? Maybe we'll sell it to you for a higher price. We'll engage in what an economist would call price discrimination. But we're going to sell to the home market, and we'll figure out what to do with you guys later. Now, the problem, of course, with these kinds of legends attached to these kind of physical objects is that they're not self-executing, right? The fact that this says not licensed for radio broadcast doesn't mean somehow that when the radio station puts this disc on their record player and plays it, that it won't play, right? You need some sort of, well, who could imagine what kind of technology that would look like, right? That would make it possible to actually block, right, the playing of this in one context and allow it in another context. That will be there soon, right? But back then they didn't have that. So as soon as, of course, records were played on radios, we had lawsuits. And so RCA sues and brings this lawsuit that goes to the Second Circuit. Copyright cases are disproportionately heard in New York and California because obviously the Los Angeles, lots of copyright issues there. Same in New York. So the Second Circuit's in New York, the Ninth Circuit's in Los Angeles. This says, no, I'm sorry. Once you sort of get the copyright, a certain controls attached to what you can do with it, your effort to control these through this legend, we're not going to allow you to limit it. That would seem to be an unlimited possibility. Copyright's supposed to be for a finite number of years. If we allowed this legend to act in that way as such, right, then you'd be able to extend copyright almost indefinitely or something like that. Won't let you to do it. Okay? So the response in the legal system to these efforts to control through legends of the sort that we saw in Bobbs-Merrill or legends of the sort that we saw there, I think ultimately wasn't very successful, right? But now we've entered the stage 4 era that I described. One-by-one production, book mediation. That's going to be a different world. So we start with the Kindle, I guess. How many Kindle owners in the room? Yeah? Okay. Kindle didn't excite me. I want color, black and white. Who cares? Okay, sorry. I remember what it was like when we persuaded ourselves that we didn't really need color on our computers. Yeah, we were wrong. Okay, so the Kindle, right? We know what the Kindle looks like. The Kindle is Amazon's, enormously successful product. The Amazon, one of the great innovations of the Kindle is it has a very controlled built-in wireless such that you can push a button and buy a book, instant gratification, right? Get books delivered in less than 60 seconds, no PC required. It's untethered as we talk about these things today. So the Kindle's been a great success for Amazon, and raises a whole bunch of interesting questions about what prices are we going to have for electronic books, and the book industry is struggling with that question. Go to the Kindle store and, lots and lots of books available with the Kindle. But it also comes with a contract, right? So when I said, who could imagine that every time you buy a book, you sign a contract? Amazon is the answer to that, right? So the Kindle is very much a device where there is a license agreement in terms of use that controls, what you're getting, what Amazon's getting, what you can do, what Amazon can do. Right? So very much, the possibility of mediation of the sort that I'm describing, this device mediation, brings with it the possibility of a kind of low-cost, instantaneous contracting, right, of the sort that Bobbs Merrill tried to do in some version in The Castaway, but did unsuccessfully. But now, that's part and parcel of what you get when you come with this. Right? And Amazon has, as many of these do, if you haven't read your Kindle terms of use, I should ask. Let's do that quickly. How many Kindle owners? How many of them have read the terms of use? Hands go down. Oh, one hand stays up. Okay. Whose hand stays up? The guy operating the electronics equipment. Okay. All right. Yeah. Not a random distribution there, right? Okay, I got it. Right? Okay, so Amazon, has enormous control over what you can do with this device, right? Turn off your wireless connectivity. That'll make the Kindle attractive, right? We get to update your software whenever we need to. Modify, suspend, discontinue, right? All these things that Amazon gets to do. Well, what does that look like in practice? Well, two examples are noteworthy. So when Amazon rolled out the Kindle 2, the Authors Guild, which is a very active organization who works on the behalf of authors, or at least that's how they think of themselves, they're more controversial than that, noted that all of a sudden the Kindle 2 had a text-to-speech function, which meant that it would read aloud the books, right? Text-to-speech, which, that can be a nice thing to do. I mean, sometimes you don't want to, you're driving in the car maybe, and you've decided correctly that reading and driving simultaneously is actually not a good choice, right? Well, okay, then you could have the Kindle 2 read out loud to you. I could see doing that, actually. I've listened to books on tape in the car, certainly. So that's what this does. And the Authors Guild says, ooh, we're not so sure about that. Very concerned that somehow this would put pressure on the books on tapes or books on CD market. Some sort of tricky questions of copyright there. And then the possibility of a lawsuit with the Electronic Frontier Foundation saying there's no way that this violates copyright. The Authors Guild saying maybe it does. But I think Amazon quickly backed up and turned it off. That's what's interesting, right? Turned it off, right? So they made it such that if the book you're downloading doesn't say you can do that, that feature is turned off on your device, right? The device you have in your hands, I've done some other work on these things, right? They are evolving products, right? This chair, right, we bought it. It hasn't changed since we bought it, right? These other devices, you take them home, they change in your hands, right? That's what's different about them, right? It's got this Skynet feel to it. I don't know if you know what Skynet is. Skynet's sort of the computer system that starts to go crazy in the Terminator movies, right? there is a feel to that here, right? These devices, you think you own them. They come subject to a contract, and that contract says Amazon can make the following changes. Okay, so this one, got a certain amount of attention, but this is the one that got a lot of attention. So here's what happens here. So Amazon, has this bookstore, and books get into the bookstore. And, they want to encourage people to put books in the bookstore. There was a great story in the Wall Street Journal on, electronic book sales in the last week. Terrific story. Authors who couldn't get published, selling electronic books and actually making a fair chunk of money and then getting them published as physical books. So, but what happened is that a version of 1984, Orwell's 1984, got into the Amazon store, and Amazon sold a few copies of that, and Amazon subsequently realized that the publishers of this electronic book did not have appropriate copyrights to do that. Okay? And so the distribution of those books is almost certainly a copyright violation. Amazon had a solution for that. It reached out and erased those books on people's Kindles. Right? I laugh because, if they were erasing, this book on dinosaurs, that would be unfortunate, right? To erase 1984? Wow, what an enormous irony, right? So this fear of this Orwellian technology, right? They erased 1984. Now, the good side of that is you say, wow, finally a meaningful system of copyright infringement, right? I mean, this is a system where if they infringe, they can undo the infringement. Authors have complained about this for years. The downside is it sort of raises the specter, right, of this ability to control at a distance, right, to exercise enormous control over the works in your hands, and the associated fears with that. So remember my story here. My story here was one of, in some sense, technology changing such that we're able to reproduce these things. Now technology is changing again such that we're able to reach out and erase these things. Okay. Amazon apologized, said we didn't mean to do that, so they won't do it again. I guess we'll see. All right, one more story, and then I'll stop. So the Kindle's one example, and devices like that are one example of the new book mediation. The next one, of course, is the Google Book Search settlement. Google Book Search and the settlement. So Google Book Search, if you haven't used Google Book Search, you should use it. It's wonderful. It's a great product. Razors and Blades research I've been doing enormously easier because of the fact that all the stuff before 1923 is in the public domain, and I can go, I'm really interested in Razors and Blades ads, right? That's where all the pricing information is, and the business model information. I'm not interested in stories, and there aren't that many stories. It's the advertising. Gillette, as you may have seen, has a full-page ad of a new razor they're selling as of today in today's New York Times. That was so exciting. And I say that not that being that interested in shaving, if the truth be known, though I did this morning to come here. Okay. All right, Google Book Search. So as you know, you run a search. Google believes correctly that if you want to know where the great content is, it's not necessarily in the latest blog post, though I do blogging. So, but it's in the world's libraries. That's where the great content is, right? So Google set up this digitization project, deals with Michigan, deals with other places. We're involved, as Judy explained. Well, Judy can tell you how many of our books they want. It's a surprising number, right? Okay. If you go there, the early business model was a business model of, well, maybe we'll, act as agent effectively and maybe get a commission when we induce someone to go buy a book. We've got links here. Maybe we'll run some ads. But eventually, the Authors Guild sues Google. Says, oh, this copying thing you're doing, this digitization, that's a copyright violation, and you've done it 10 million times. Let's count that. Copyright damages can range as, the actual damages, and statutory damages can go up to $150,000 per book. Let's do that multiplication and see if Sergey and Larry care about that number. So a lawsuit emerges. And what usually follows a lawsuit is a settlement. And that's what we have. So the Google Book Search settlement is pending. That settlement is enormously complicated. I've written, I think, 3 papers on it, so you can download, read those if you want to. But I'll do the simple version. And the simple version is to say, well, look, what Google has created is this digital files collection, these scans of these books. A lot of effort there, a lot of money. Though in the grand scheme of things, not huge amounts of money. I mean, we're talking hundreds of millions is maybe the order of magnitude. A lot of money, but not if you're a big company. To create that collection, but it's not clear what they can do with it, right? Google will say, well, here's why we think under copyright we can use these in the following ways. I've testified on this issue in front of Congress. Dave Drummond, who's their chief legal officer, was there. I mean, they have a story. They can explain why they think that's right. I don't think anyone knows what would actually happen if we litigated that. It's not clear. That's easy. But they have a story as to why they might win. But they also say, look, we'd rather settle. And so what they need is some sort of rights license for the files they've created. And they've got, the people to talk to do that. Now, the problem is that, for living authors, it's pretty straightforward to know who you go talk to, maybe. You go talk to the author, you talk to the publisher. The problem is what we call orphan works. That's the real problem. Orphan works are works that we can't really tell who controls the copyright to the work, right? Maybe the company that published it has gone out of business. Maybe the author's dead. Copyright these days lasts life of the author plus 70 years, right? If I died, who would get the rights to my books? How do we track those down? So it's one thing to say, oh, I'll do a deal with living authors or living publishers and the like, and Google's done a bunch of deals with that, like that. The tricky copyright problem, or the orphan works. And the way the lawsuit was organized, it was organized as a collective action. And then I'll sound, law for a second, as an opt-out class action. And an opt-out class action means that the way the class action is set up, you've probably been in one of these for some product, right? They say, you're in this lawsuit with us unless you say you want out. It's called an opt-out. And you have to send us a piece of paper saying you want out. Well, what's devious, I'm not sure, about what Google has done here is Google basically said, okay, authors of the world, well, shrunk down to authors of the United States, right? Okay, authors of the United States, here's the settlement, and if you want out, tell us about it. Well, of course, the whole problem is no one has a clue who the orphan authors are. And so they are being, as it were, sucked into this in a way that solves the orphan works problem in a way that Congress has refused to do through legislation, but solves it only as to Google. Right? Only Google will effectively have this power to issue these licenses and to distribute the orphan works. And that's a concern, right? So I say a concern. I mean, the librarians are concerned about high prices and monopoly power there. The antitrust lawyer in me says, actually, being a monopoly is not a problem in the United States. That we applaud you. You can charge high prices abusing your monopoly power. Right, that's what gives rise to a problem, and charging high prices doesn't do that. But there are certainly aspects of the settlement which I think give rise to antitrust issues. The fact that I think that's interesting, the fact that the Department of Justice thinks that's important. And so that case is still pending. The district court judge who's before has gotten a promotion, so he's gone from the district court to the Second Circuit, so it's a little unclear what's going to happen. A number of us have asked the court, as it were, to broaden the license that's being issued. We love Google Book Search. We want to see it get out there, but we want to see it done in as competitive a fashion as possible. And the case sits before Judge Chin, and it's not clear what's going to happen. So we've moved rapidly, right, from the monks and the scriptorium to Gutenberg to Sony to Xerox to Sean Fanning, and now to this world of book mediation, where the technological response is, again, to exercise control at a distance. It's a very interesting era. Thanks.